Notary Tax Work Group. I'm Mark Comstock, erstwhile leader. Let's go around the room first and then we'll figure out who we've got out in the ether. To my right.
Jamie Weddle with the Secretary of State, Corporation Division.
I'm Ruth Miles. I'm the Director of the Corporation Division and the Tribal Liaison for Secretary of State.
Thomas Cuomo here on behalf of the Oregon Mortgage Bankers Association.
Matt Markey, Mortgage Bankers Association.
And Heather Gilmore, I'm an attorney in private practice.
Amy Guptill, Oregon State Bar.
Shannon Moore, Judiciary Council.
Sandy Free, Oregon Judicial Department.
So, Sandy Weintraub from the Oregon Law Commission. We have like 11 people on the phone, so I apologize for, it's going to be a bit difficult, but we'll try to go one at a time.
So queue up out there in the ether and identify yourself.
Cleve Abbey. MBA.
Thanks, Cleve.
Thanks.
Marisa James from Legislative Council.
Thanks for being here, Marisa.
Renee Alberti from
Sherman.
Notarized. Oh, sorry, go ahead.
Ken Sherman for the Oregon Bankers Association.
Renee and Ken, thank you.
Toby Pruitt, MBA.
Greg Trummel, First American.
Michael O'Neill at First American.
Melissa May, attorney in private practice.
Tommy Brooks, private practice.
Rochelle Long.
Liz Basemeyer. Sorry.
Thank you, Rochelle.
I think Liz is all, Liz Facemeyer.
Was that Liz?
Liz with Quicken Loans. Yep.
Thanks, Liz.
Thank you.
Anyone else out there who hasn't identified? Okay.
Okay, sounds like we're here. Well, thanks for participating and welcome all. Hopefully this is the culmination of our meetings of the work group. We're hoping. I hope everyone got Sandy's emails with the LC 9990 draft and a couple other discussions. First point that we've got to discuss is first the papering out provisions. Sandy, maybe you can tell us what you mean by papering out.
So it was a discussion last time that I know a couple folks, I believe Cleve and Michael O'Neill were the two who did the work on this, and then Marisa was able to incorporate it into the draft statute. So I'd actually, if Cleve or Michael would like to discuss the changes, and if anyone had any comments on the way that Marisa was able to incorporate that into the statute.
Michael, why don't you go ahead with that?
Sure. So papering out is a provision that's part of the uniform law. And what that actually refers to is a way to try to get electronically signed and notarized documents recorded in the land records. So this is real estate documents intended to apply to real estate documents only, to get them recorded in a situation where a recorder does not accept electronic filing of documents. Now, there is electronic filing statewide in Oregon, so there is an ability to record everywhere. But of course, there could be situations where it could still be useful if recording systems were down, for example, and people had to walk documents in. And so incorporating and keeping that provision of the uniform law probably still has some utility in the state. Papering out is really two separate things or concepts that are combined. The first is the ability of a notary to make a certified copy of a document that notary prints off or supervises the printing of. Basically, a document's notarized electronically. It's a PDF that the notary opens up, and the notary can print off that document and add a certification to it that this is a true and correct copy of the electronic original. So that's the first step, is creating this new notarial power in Section 4C of RULONA. The second step is saying, Well, a document that has been so certified by a notary, that document satisfies any requirement that a document that's submitted in person be an original document or have original signatures on the document. And so it's also papering out as part a notary power, and it is part a recording act power. And so the way that we have drafted, the way the draft now reads, is it makes clear that papering out applies to the county clerks who record documents. So it is a real estate recording provision only. And so, and we discussed some of this on our last call, the exact verbiage to use, but I think the draft as it now stands reflects the consensus that we all reached on our last call. I don't know if there's any questions or other folks have comments about the language as it stands.
This is Marisa. I added in this section 6 that is sort of a, well, you were calling it a curative provision to ratify documents that were recorded before the act becomes effective. So if you looked at that. That's Cleve, I don't know if you want to explain some of that too. So this is a sort of a standard. If you look in the recording acts, there's lots of curative provisions. Essentially, whenever there's a substantive change to recording law, you want to make sure from a real estate title standpoint to ensure the security of titles and that they're not going to be challenged, that anything recorded prior to that is cured by the as long as it conforms up into the date of the change in the recording statutes. And so Cleve and the Oregon Land Title Association are proposing those curative provisions to encompass documents that may have been papered out and recorded prior to this change, now providing an express procedure to do so, and likewise for documents that were electronically recorded.
Okay. Heather, you had a question?
I didn't have any technical input. I thought it was fine, but it was cumbersome to read, and it took me a couple of times just looking at it, and I think there's too many VATs in there. So, Marissa, I'm looking at section 6, and I'm looking at the blank section numbers at the end, on the OLCA version, and it says, currently it says, an instrument that is presented for recording as an electronic image, and it should just say, an instrument presented for recording as an electronic image. And then down in the next line after January 1st, and instead of the word, and that as county clerk reports, it should just be, and a county clerk records. There's just so many that in a short period of time that didn't add anything. It made it messy, and there's a couple of times over in section 6. It is appropriate to include that in certain circumstances, but this statute is so that-y that I didn't think it complied with how legislative council drafts. Marissa?
Sure. I mean, I'm open to any suggestions. I think this came from Rulona, right? In section 5.
Yeah. That doesn't mean it's not.
Do you want to vary from Rulona then?
To take out the that make it confusing?
I mean,
not well
sure, you can change what the uniform law says. I guess you run the risk that somebody's going to interpret that to be an intentional difference from what the uniform law said.
Okay, we'll just leave it in. I think it doesn't add to the reading of the statute.
Well, to the extent that we want to rely on the comments that Lona sent along in their drafting as legislative history for this,
we could just say in a comment, we removed a bunch of that because they were unnecessary. Seriously, they're bad. Sorry, I'm an editor. So.
I have no problem with removing words as long as it doesn't really change the the substance of this, and I kind of defer to legislative counsel on that part of it. Anyone else have questions? Go ahead.
Oh, this is Marisa again. I mean, it makes sense to me the way it's written, but I mean, everything can always be improved, so. But when it's a uniform act, we hesitate to change what the drafters of the uniform act, I mean, if the intention of adopting the uniform act is to get the uniform treatment across the states, then I don't see why you would change it.
Okay.
All right. Now, well, is there a consensus to simply adopt what Marissa has drafted here on the, at least for the papering out sections here?
Yeah, if Marissa's concerned about it, I don't think we should change it, but, yeah.
Okay. Okay. Well, I'm taking that as a consensus unless I hear an objection. And hearing none, let's move on.
Art,
Yep.
This is Cleve. Are we talking about, when Michael and I sent something into Sandy, it was these unnumbered sections at the end. And I don't think we had the benefit of looking at section 6. So is the proposal to leave all of these provisions in, or maybe take, if there's overlap between section 6 and the unnumbered sections at the end, maybe that's worth at least talking about.
And I'm presuming that you're referring to what has been circulated as the curative document?
Yeah.
That we have sections blank blank at the end of that section.
Yes.
And I'm going to ask Marissa, did we kind of look to see if we've got overlap or at least have the concepts that are proposed there in the curative document in the LC draft?
Yeah, so I mean, I only included one of them because that's the one that made sense to me. It's because this was from another concept that I didn't think that we needed the electronic image part of it because that's not included in our draft. But I could be wrong about that.
I'm a bit confused. I thought that the LC draft had the electronic image provision in there. Am I just missing?
It has the second unnumbered provision, basically, but not the first one on that curative provision.
Okay.
The tangible copy of an electronic record, because that mirrors the language that's in Rulona.
Okay. So, Cleve, or Matt, you can tell me why we need the curative language in addition?
Well, I'm not tracking it.
Okay. In section 3 of section 3 sub 3 is in the LC draft is the ability of the notarial officer to certify a tangible copy of an electronic record is accurate.
Is that right? Is that?
Is that sufficient to address your curative?
Well, the curative one means that if it was certified before the Section 3 took effect, that it would still have, it would still be a valid recording, if you will. So that's the curative. This fixes it on a kind of a go-forward basis, and the Curative Act says if we did it before the new law took effect, then it's still good. And one of the concerns is you probably can't really tell a document from whether it's before or after the bill takes effect. So
That's section 6, yeah.
That's section 6, yeah.
Yeah, so Cleve, I
On
think
the
the
front
concern, Cleve, this is Michael. I think the concern is that up until this act takes effect, notaries don't have the power to make certified copies of electronic records. So it's not likely that that has ever happened.
Yeah.
So until 4C actually gets enacted of RLONA, that's probably not what has actually taken place out there. But what may have taken place is someone who submits a document in paper under, for example, the Uniform Electronic Transactions Act, and which permits the use of electronic documents broadly for all governmental purposes. And what may have happened is someone who has recorded a document that was not an original, but was a papered out document that does not contain the certification. And that's what would not be detectable in the land records. So I think when you and I discussed this provision a couple of weeks ago, the thinking that you had was that the curative provision should cover any papered out documents that had not been certified prior to the date of this act, because there was no mechanism for doing that. But on a go forward basis, now there is a mechanism. And so the curative provision would not apply going forward.
So section 6 of the LC draft, does that handle it?
Well, the last clause after the comma, I think, is the difference. So if we removed everything,
but
okay, if we removed everything
after the word original, instead of a comma, put a period there. And then above that, the words containing a notarial certificate.
So then there would be no record that it was an original. I mean, then anybody could have recorded a tangible copy of an electronic record, but there was nobody certifying that it was identical to the original. Is that what you want?
Yeah, I think that's exactly the concern, is that without a previous papering out provision, these things could have gotten recorded, and there would be no way to know from looking at the recorded public records whether a document was in fact printed off and submitted without a certification.
So if the county clerk accepted it, we're just going to call it good. And I mean, that's fine if that's what you want. I just want to make sure.
I think the county clerks might get a little upset about that.
We have a county clerk on the line today, actually.
Let's hear from the county clerks.
Rochelle, do you have any thoughts?
You may be on mute. Okay. So let me see if I can understand. The LC draft as written requires the certification currently of the document that somebody may have done previously. Doesn't that give us more protection that the document is the true and accurate image?
It would, but as a factual matter, that has never happened, because a notary has not had this power to make a certified copy of an electronic original prior to this act.
In that case, it sounds like maybe you don't need the curative provision because it's never happened before, so there's nothing to cure.
Well, it has never been certified and submitted, but documents could have been recorded without the certification. You print off an electronic document in color format, for example, and the signatures look like wedding signatures, and it looks like a notarized document, and it's submitted in person, and that document may well have been recorded as a papered out document, and there'd be no way to know from looking at the recorded record of that document that in fact took place.
I am not following that.
Yeah, I guess I'm,
I don't see.
I'm like you are.
Yeah.
I'm not following what the difference is here.
So presumably, if the document was recorded prior to adoption of this act and its active date, then there should be a notarial certificate along with it.
Yeah.
And that would show that this was in fact the original. And if there isn't a notarial certificate associated with it, then that would be presumably a sort of recording error for which Secretary of State, Corporation Division, and notaries can't take responsibility. And I'm not sure
I think there may be some confusion about the phrase notarial certificate in Rolona, because it's not really clear on the face of it what it's referring to. We're not talking about the acknowledgement or the certificate of acknowledgement that would be, for example, on a deed. That's not the notarial certificate that entitles something to be papered out and recorded. It must contain a separate notarial certificate. So if you imagine a deed that contains a document where someone has signed the document, signed the deed, below that it contains an acknowledgement block that a notary has filled out. Then on a separate piece of paper or below that, there is another notarial certificate that says, I hereby certify that this was a tangible copy of an electronic record. And it's that second notarial certificate that entitles it to be recorded under Rolona 2018, that certified copy certification, which could be a different notary than the notary who notarized the signature of the signer to the deed itself. And so can you imagine a document is signed electronically by an electronic notary or notary doing a remote notarization, and then yet another notary working for a title company or for a bank prints off that document and attaches to it a certification that this is a certified copy of the document that I printed. And that becomes entitled to be recorded. So if a notary didn't have that power to make a certified copy, then there could have been recordings of documents prior to enactment of this act that facially, you could not tell whether or not they were submitted as originals or not at the time of recording. But they would nonetheless contain signatures and a notary acknowledgement on them.
Go ahead, Ruth.
So ORS 194.
I want to make sure I'm stating this correctly. The request is coming from OLTA, the Land Title Association, and I think it was just consistent with their practices of whenever we have a change to recording acts, non-conforming recordings that are not detectable prior to that change, just as a matter of course, there's a whole list of curative provisions in the recording statutes, and OLTA's position was that things that would fall into that or could be affected by that should be cured at the point of the change.
Ruth, did you have a question?
So ORS 194 8C does allow notaries to certify or attest a copy right now. That's existing statute.
194.
194.215 8C. And it's just among the definition of notarial act, and what those various things are. So these are essentially the current powers and authorities of a notary. And certifying or attesting a copy is definitely in there. But it doesn't, because the statute doesn't include information about remote notarization, there is some information about what electronic means or what an electronic signature is. But the statute as it currently sits, doesn't really discuss remote notarizations, which is why we're here, right? But all that understood, you know, so if a county clerk is presented with a certified copy or a copy that a notary has attested to what's the word I want?
True and accurate copy.
Thank you. That's what I was looking for. And that's presented to a county clerk. Do we still need this curative provision in the draft? I just am not seeing the reason for that. And I get that there might be two certificates. One is the original notarization. One is the attestation that this is a true and correct copy, or a certified copy of the original. But what I'm not seeing is why that's a problem for county clerks.
Okay, I toss it back to you, Cleve.
Yeah, I don't, I mean, are we talking about removing, section 6 or just changing it? And
I think we're talking about keeping section 6 as it's written.
Right.
In the LC draft, because I think it does what we need to do. I'm just trying to figure out what the curative document language changes, or why it might be better.
Yeah, my proposal, and this is Ruth from Corporation Division, my proposal is that we don't add the curative provisions that are unnumbered on that separate document into the LC draft.
Okay.
But we do.
This is Marisa. So the first one there, I was going to ask. Oh, all of the ones that are unnumbered. I see. Never mind. Go ahead.
Okay.
So would all of section 6 remain the way it is in this draft?
Well, that's what we're proposing, or at least that's what I understand Ruth is proposing. Any other questions or discussion, or?
So I just want to make sure I understand the basics. I think what this statute says is only before the act is operative, if somebody wants to record something and it's electronic, they can do so. So then the question is, what requirements will there be before the act is operative for that recording?
Okay.
Is that the accurate summary?
And I think so, and section 6, I think, simply, section 6 of the LC draft, it identifies that, yes, you can do that, and you've got the authority even before the act is effective.
But in order to do that, you have to have a supplemental certificate under the way it's drafted. You have to have a supplemental certificate saying this is the original.
And
Right, and that's the last section.
yeah, and I understand that this may be a belt and suspenders kind of situation, because the statute already in 8C or D or whatever it is, already provides that a notary can attest that a document is a true copy, true and correct copy. So I think we're talking belt and suspenders here. Am I missing something, Cleve, or, because?
No, I don't think so.
And Michael, am I missing it, or, I mean, it could be a high, hard, fast one by me. That's easy.
No, I don't think you're missing it. It's just today if you make a certified or attest a copy, that is not entitled to be recorded. And so I don't think documents that are being certified as copies are in fact being recorded. So I don't think that this actually, it would cure that if that were to have happened, but I don't think as a factual matter that has ever happened. And so when
Can I say
Cleve and
something from the recording perspective?
You bet.
Yes.
Okay, so we can record certified copies, but it can't be a certified thing from a notary. We can't record that.
Certified thing,
And then, is this for Rochelle?
So like if a notarial act happens and they say this is a true and correct copy of my notarial act, we wouldn't record that. It has to be the original or it has to be e-recorded, electronically recorded. The whole thing has to come in electronically. A certified copy would be a certified copy from the Secretary of State's office, from Vital Records, or from another county office clerk.
okay, so the language of Section 6 of the LC draft as it's proposed, would that be sufficient to allow you as a recording officer to record this attestation of true and correct copy?
The way that it's worded, the way that I would take that, but I'm not an attorney, and so I would definitely be having someone look this over. I would take that as, yes, I could record that certified from the notary saying that they actually notarized that document. Yes, I would say I could.
Okay. I think that's the location we want to be.
Okay,
Go ahead.
but just me saying that, I should be clear. But the certified copy itself would still need to come from whoever's offering that certified copy. I mean, the person, they can bring in a thing over the counter that was all done electronically. That's fine. We can technically record those now. If the whole transaction is done electronically, and someone were to print it off and bring it in, that actually passed in statute, so we can actually do that now.
Okay, so at worst, this language may be just surplusage, but at best, it gets to where we want to go. Is that an accurate summary?
I think so. I think that it would allow for someone that had hesitation to be like, okay, well, they're adding that extra attestation, basically, saying that they actually did it, and so I think that would work, yes.
Okay. Does anyone object to the LC draft section 6 as written? Now is your time to object. Hearing none, let's move on. Okay. And the next item is Ken's comments about Section 2, I think, and that was in Sandy's...
Yeah, I sent it out yesterday.
Sandy's email of yesterday, which looks at Section 2, 3, AB, I guess. And it has the language, affirmation from a credible witness appearing before the notary public. I think that Ken has a question about what's a credible witness, and second, where is the credible witness doing their appearing? Is it before the notary, or remote notary, or is it somewhere else? Have I accurately kind of summarized that, Ken?
Yes, you have.
Okay.
So, this kind of flies in the face of those of us, and I am one of them, who says vary from the uniform language only at your peril and when really necessary. So I'm not overly excited about this, but the word credible to me is pretty vague, and so I thought maybe it would benefit from some attempt to define what we're talking about so that we don't have notaries out there who have to decide for themselves what credible means. And then the appearing before provision, as I said in my notes, there is a comment about that in the official comments. However, those are rarely, if ever, seen by people other than committees like this. And so I just wondered if it wouldn't be useful to clarify the statute. And I assume we'd want to do that by saying something like appearing either in person or remotely, as opposed to just saying appearing. Again, I don't think either one of these things is a huge change, and I certainly don't see them as reason to be concerned about passing this bill into law.
Well, at least as I read 194-240 as it exists right now, we have credible witness personally appearing in it already, and I guess the statute circumscribes what is presented to the notarial officer to be proof of identity. And I quite frankly haven't looked where credible witness came from, if it's the prior Uniform Act.
I can sort of answer, this is Michael O'Neill. The credible witness is a creature of common law, and so some states have defined it statutorily, but the Uniform Acts have never done so, and so it's assumed when the Uniform Act is using the phrase credible witness, they're just using that common law notarial definition. And so all the Uniform Act imposes is a requirement for how to identify the credible witness, but it looks back to the common law as to what makes someone a credible witness. To the extent that helps any as an explanation. Yeah. But I think Kent's point is that it's not, the drafting is not entirely crystal clear that the credible witness can be either A, physically in the presence of the notary and then present the identification documents in 240B, or be remote and be subjected to identity proofing. The official comments to Rolona make that very clear, that exact point. But if you look at the phrase in that credible witness section itself, it simply says appearing before the notary under 240B or this section. So it's extremely terse, but the official comments make clear that it's intended, at least, to mean physically present a driver's license in the physical presence of the notary or be a remote individual and be subjected to identity proofing.
Well,
and this terseness has been the subject of some confusion, I think, when people are reading that section.
Okay, let's, Heather, you had a question?
Yeah, for the software people, how does that happen? In a practical matter, you have your remote notary pop up after all the identity proofing to start, and then you have Bobby, the grandson, in the room with Grandma, and he's going to attest to the identity of Grandma. How do we know what Bobby's identity is? Does he go through a separate entry in the notarization, or how does that work?
At least I take it, and I'm going to defer to the professionals that do this, but I think that in your example, Bobby has to have a copy of his driver's license or passport or whatever it is, with the appropriate copies of the pages that appear on the screen or whatever device you're using to remotely appear. At least tell me somebody who knows how this works. Tell me how it works.
This is covered in current statute under ORS 194.240, and it's sub 2BB. It goes on, but toward the end of that section of the ORS, it talks about by verification of oath or affirmation of a credible witness, personally appearing before the officer, the notary here, and known to the officer or whom the officer can identify on the basis of passport, driver's license, identification card issued under ORS 807.400, and it goes on, like military ID card, and gives you all the different
I know they have
instruments.
to have that ID, but my question is to the software people, do they have to do that, those 3 questions? Or they just show their ID?
Liz, I'm going to defer to you.
I'm sorry, say it again, it was hard to hear.
In Heather's example, where it's Bobby that's in the room with Grandma, and Grandma is signing some document that needs a notary on it, and Bobby is saying, yes, this is Grandma, and does Bobby have to have some acceptable piece of ID that is shown on the recording?
Yeah, that's not my question. My question is, does Bobby have to go through the questions to verify identity, or does he just have his ID alone?
Did you hear that, Liz?
So you're asking if the nephew in the room has to do his own identification things along with Grandma, if he's not actually signing anything?
Yeah.
No, he would not. But if the notary feels like something funky is going on, they can cancel the closing. And if it's really up to the notary at that point to see, was he answering them for her? Does she really know that what she's signing? It's the same kind of thing in person that you would see if they were both in the room. You don't get the exact sense because they're obviously not right in front of you, but
So Bobby just showed
you can
his
ask
ID
who.
on camera is the answer.
Well, now let me specifically ask that. Can then Bobby, who's in the room with Grandma, simply show his government-issued picture ID, both sides of it, and that could assuage the identification issue of Grandma?
No, you shouldn't be able to do that because when it picks up the ID from him, it shows the notary before the session begins that it's, Joe Schmo provided his ID instead of the person that's actually supposed to be signing the documents, which is Grandma. And then the notary could not even start the session at that point because they already know that she didn't provide her ID, or maybe there was some confusion, but there's something going on where Grandma didn't do it right. So maybe the Ron closing is not the best for her.
The answer to this under Rolona is that if Bobby is remote and with Grandma in the same room, and Bobby is the credible witness to identify Grandma, the notary must either have personal knowledge of Bobby, or Bobby has to go through the same identity proofing processes that Grandma would have gone through.
In a separate session.
So yes,
Correct.
I agree with
So
Michael there.
answering the questions.
From our system's perspective, states that do allow credible witness, is the credible witness at the front end has to go through the entire credential analysis and KVA process.
Thank you, Renee.
Okay.
Sorry, guys, there was a little bit of muffling. I didn't know we were still on the credible witness part. My bad. I'm still trying to follow. Thank you, guys.
I think we've got the answer, is that, yes.
Identity proofing.
Yeah, it's the identity proofing, and if Bobby is certifying that Grandma's Grandma, he has to be...
Certify the QT, yeah. And we would prefer this.
Okay.
This gives the notary more certainty to have that person go through identity proofing.
When we went back and forth over the elder law issue, if Bobby is there with the lady, he says it's his grandma, at least we have a video of it. If Bobby takes Grandma to the UPS store, or the lady he says is Grandma, we have nothing except for the UPS, but maybe remembering,
So here, under the proposed act, we'd have better evidence of actually
who Bobby is.
Well, who Bobby is and who, picture of Grandma.
And
Okay.
what the demeanor of Grandma was at the time that she signed. Yeah,
Okay, so let's go back to what does credible add to this statute, and do we need it?
Mr. Chair, this is Tim Reininger on the phone. If I may interject a little bit using my experience as former executive director of the National Notary Association, all that, and with these laws, I'll say that I think for us, of course, as Americans, the idea of credible witness seems like something like back to ancient times, and it just seems like it doesn't really fit with what we're talking about. But it's important, as Michael noted, up until the time of driver's licenses, notaries only could proceed with either personal knowledge directly or with credible witnesses under oath, vouching witnesses. All. But what we're seeing now is this is now critically important from the perspective of in Oregon for its reach. When you consider in the world there are over 1 billion people without any type of legal credential, of identity credential. And you've got outside the United States, you can't do any type of knowledge-based questioning processes really for people coming out of a lot of modern, even European countries with identity credentials and all that. So you're left with probably it's important to have that authorization for a credible witness in the law so that it would enable some possibility of proceeding. And so, an example, well, we've already gone through some examples, but, if you have Lou Costello coming from Italy, and Michael O'Neill is the notary, and he knows Bud Abbott, then that would be the only way to proceed with Lou Costello, because we couldn't do a KBA on him from Italy, or even do a credential analysis on his Italian credential. So so this would play out a lot. So I would say I don't know, be overreaching and advocating, but I would say this is an important authority and power for Oregon to retain to enhance to maximize the effectiveness of the law.
Okay. I'm just, as we've had this discussion, I'm sitting here, okay, I'm the judge, and I'm looking at this recording, and I've got to make a determination if there was, let's say, competency of the execution here. It may be a little bit far-fetched, but I think credible in the statute gives the judge the discretion to make a determination, whereas if credible was not in the statute, the judge would simply be left with, was there a witness saying X? So I think credible adds some discretion to the court to make its own determination, and I think that's something we want to be having for judges to be comfortable with this remote notarization, acknowledging that judges are probably not going to be very accommodating of remote electronic notarization. But that's kind of my thought process. So I'd like to hear from Ken maybe on that, about whether or not credible does need to stay in this statute.
I think based on the discussion we've had, it's appropriate to leave it the way it is and include the word credible. The tie back to 194, 240, and the provisions in that statute that describe how you go about determining credibility, I think is helpful. So I'm okay with that part of it.
Okay, great.
And that's my first question.
Anybody else uncomfortable with keeping or with Ken's question about credible? Hearing none, I think we've got that question answered. I think we now come to, are we recommending the draft as written that Marissa's come up with? The LC 99. Go ahead.
One change I do want to make is, now that we've talked through these curative provisions, I think those should become effective on the 91st day, and that's not how I have it in this. So I would change Section 8 to just apply the delayed operative date to section 2 and the amendments to the statutes rather than also to section 6. So that is the one change I think needs to be made.
Okay.
Mark, this is Cleve. There's one question I had, but maybe is relevant now. But in section 2, sub 1B, there's the definition of foreign state, and it appears not to include U.S. territory like Puerto Rico. Is that intended, or that phrase "foreign state" I think is only used in one other place, and that's on page 2, kind of in the middle. It's small d, capital B.
I believe this is Michael. That's captured under the definition of state.
Right.
In,
yeah, that's what I was just going to ask.
215. Yeah. So state is defined as Puerto Rico, territories, etc. DC.
Or whatever an insular possession is.
Good.
Mark?
Okay. Yep.
Mark, we dealt with the creditable witness question, but I still think there is perhaps a question regarding whether the credible witness has to be physically in the presence of the notary or not. The comments suggest not, but the cross-reference to 194-240 talks about, that section talks about the witness appearing, personally appearing for the officer. So I think there's still some room for confusion when we get to this section of our bill as to whether the person must be in the presence or can appear remotely.
Okay. Well, let's get that figured out here.
Because it does cross-reference 194-240 sub 2, which talks about personally appearing. And I take it that personally appearing means you're in the room.
Well, it's under this section or 194-242. So that says to me that it could be under the remote notarization provisions or under that one.
But I don't think there's anything in this section of the bill that speaks about whether the person has to be in the room or can appear remotely. And again, the comments seem to respond to that, but I don't think it's fair to notaries out there that we make them go to the comments or be familiar with the comments to know what they can do here.
So are you thinking of adding clarifying language to?
Yeah, I had suggested in the notes that we could add something like appearing, let's see, appearing personally or remotely, or either personally or remotely, something like that. I don't think we need much of a change, but I just think it is a little bit ambiguous the way it's written.
So we could define it in rule.
Well,
I'm sorry.
I will say that I've echoed these concerns about the ambiguity in drafting with the Uniform Law Commission, but my suggestions were not taken up, unfortunately. But I think that the key is that a credible witness is a remotely located individual as defined, which is simply an individual who's not in the physical presence of the notary, and that remotely located individual complies with the personal appearance requirement by using the communication technology. So you actually have to go through 3 steps to reach the conclusion. It is not entirely clear, and I have raised that point before. Many other states are addressing this in rulemaking by just being very explicit about how credible witnesses work in practice and the requirements. So I echo the comments about it not being entirely clear in the statute, but it is what it is from the Uniform Law Commission.
Talking about sections 2, 1, little a, big A, it says allows a notary public and a remotely located individual, and inherent in that concept of remotely located individual is the credible witness. Is that how you cross-reference and get that?
Did you hear that, Michael?
I did, and that's exactly right. So the way that I propose the Uniform Law Commission do this is say a credible witness appearing as a remotely located individual before a notary public under this section, or appearing in the physical presence of the notary under ORS 242. I suggested some, expansive language like that in prior comments to the Uniform Law Commission, but those were not adopted.
Could you get to the same place if you just said appearing personally or remotely? You insert those three words.
One of the issues is that a remote appearance under 194.235, a remote appearance is a personal appearance, and it qualifies as one. And so you really don't want to make the distinction between a personal and remote appearance.
I understand.
Like that. Yeah. It's a drafting conundrum, I agree.
FaceTime. Yeah, you want them to be within the structure of this remote notarization electronic signature piece, and you don't want...
Or appear in person.
Yeah, because if we aren't careful about how we do that, if you FaceTime somebody, in theory, they could say, hold the phone up to the camera. Yeah, that would be bad. So if we're going to mess with that, I think that it needs to be very... I actually liked the proposed language that the Uniform Law Commission didn't, but...
Okay. Michael, could you give us that language again? I don't think you wrote it down.
Would it be helpful if I sent it in an email?
Yeah, if you send it to me, I can distribute it immediately.
Okay, I'll do that right now.
Okay.
Okay.
And then that addresses Ken's question. That solves it.
I think so. Ken, are you comfortable with at least the suggested language that Michael stated earlier as fixing the more words, but the short personally or remotely?
Yeah, I'm comfortable with anything that makes it clear that the credible witness may either be in the presence of the notary or may be, presumably in the presence of the person whose notarization is being accomplished. But let's just look at the language. But to me, this is not a huge point. I just thought, gosh, if I'm a notary sitting out there and it says appearing before, how am I going to read that?
Well, in concept, does everyone agree? Let me state it in the negative. Does anyone object to including Michael's proposed language to address the lack of clarity on personally versus remotely for this section of the statute, proposed statute?
Michael, I haven't gotten an email yet if you were attempting.
I just sent it a minute or two ago, so it's probably on its way.
I'll keep updating it. Oh, I just got it.
Okay, I'm not hearing any objections to that concept anyway, so let's have Sandy kind of identify where we put it in this LC 9990 draft.
So I just sent it to everybody right now, and then we can talk about how it goes.
Can you read the language?
Yeah, I can read it out loud.
Because we're still not getting it.
Sure. So the language as we're considering right now is, has satisfactory evidence of the identity of the remotely located individual by oath or affirmation from a credible witness appearing before and identified by the notary public as a remotely located individual under this section or in the physical presence of the notary public under ORS 194.240. 2.
Okay.
Anyone object to that language? Hearing none.
And Marisa, just making sure, I did send it to you as well. Do you have that for inclusion?
Yeah, I got it. Thank you.
Okay.
Okay, hearing no objection, I think we've got a proposed addition to our LC 9990 draft. Any other questions, additions, discussion about the LC 9990 draft as amended?
Can we just clarify one thing real quick? There was a comment in there about the 91st day and a change there, and I guess I didn't catch all of it, and I just wanted to make sure we're on the same page.
Yeah, Marisa, this is for you.
Yeah, I was just saying, right now, it makes Section 6 operative July 1, 2021, which is the curative provision, but now that we've talked through it, I think it makes more sense for that to take effect on the 91st day with the rest with the act, and then delay the rest of the provisions, so that curative provision goes into effect with as fast as possible.
I just want to make sure Section 8.
So all it does is change Section 8, correct?
Yeah.
Right.
Okay.
Okay. That's good. Thank you.
And that clarifies that the Secretary of State can charge off doing things before in anticipation of time passing. Okay?
Right. So the change won't become operative. Won't take. I mean, take effect isn't the right word, but it won't take effect until July 1, 2021. But before that date, the Secretary of State can make rules and get ready for the change.
Great. Okay. Is everybody on board with that change in the LC draft? Hearing no objection, I think we've got that, subject to, of course, Marissa drafting it up. Any other questions, suggestions, changes, lack of clarity, whatever we've got here, with going forward with the LC 9990 draft as amended?
And Mark, this is Cleve again. So Section 6 is in as we discussed, and then the idea to not include both of the last two unnumbered sections, or we were focusing mostly on the last one rather than the next to last one, but that's one question: are those included or not included? And then the last. The unnumbered section, which is just before those, which is an amendment to ORS 93.810, is that going to be, are the changes going to be dropped, or would they just appear as it is in the draft?
I was going to ask somebody who knows more about this statute than I do, the person who does the recording drafting, whether we need to put this Section 6, a reference to Section 6 in 93.810. So that I will do. When I was looking at the last two unnumbered sections here, this second one, the middle unnumbered section on the page, seems like it was specific to whatever draft this came from, or whatever concept this came from, and I didn't think we needed it. So, but I could be wrong about that. So if you can look at it and let me know whether just Section 6 covers it. This seemed like it was applying to a change to 93.804, which we're not changing in our draft.
Cleve?
Well, I think removing the last one is, I think the last one is duplicative with section 6.
Right, I took that one from section 6, yeah.
Okay, so the next to last unnumbered section, why is it needed?
Well, if the question is, this is recording an actual electronic image, and the way recording is working today, I think, is that a document is, an original paper document is turned into a true and accurate copy of the original, the wet paper, and or rather, excuse me, maybe I misspoke. The documents are run through a scanner, and the scanned copy is what becomes part of the public record. So it's not there's always a paper original that has to be certified as a true original, and when it gets put into the transmission to the county. So there's a link between the title company and the county, and there's some certainty that it's an original that's getting electronically recorded. So
I guess I didn't see how the notary fit into that part of the process, so maybe we don't need to cure anything with regard to our notary bill.
Yeah, that's a fair point. If there was a question about 93.810, I think that's just essentially a list of when other statutes have done something to correct what may have happened. So the curative, the operative law that is the subject of the curative provision is referred to generally in 93.810. But I think it made sense to have 93.810 recognize that there is a curative element in section 6. So I think
Okay, I will find out about that. Yeah, yes, I think you're right, probably right. I will confirm.
Okay, and Mercer, are you confirming whether we need to add a section 12 to 93.810?
Right, yes, whether we need to add our curative provision that we're creating, section 6, to the list of curative acts in 93.810. I will find out about that.
Okay. So what is the work group's sense of if Marissa's answer is in the affirmative, going forward with this?
And then at this stage, we're recommending it for consideration by the Oregon Law Commission, which happens to be meeting on Thursday.
Yeah.
So if the Oregon Law Commission would approve, then it would be, we'd work with Chana and others to make sure that our bill would be submitted for the 2020 session.
And we're just talking about the section 1 on the curative list, not the 2 unnumbered sections, right? Just to be clear.
Section 6 is the third
right
unnumbered section on this list.
Okay, so that's already there.
In the draft, section 6 has already been. Yeah.
Right, that's fine.
Right.
So as long as we're not including those unnumbered sections in other ways than they are already reflected in the draft, then yeah, I'm fine with that.
And then we
concept.
were just talking about the first unnumbered section, which I mean, I don't think it changes. It's not really a substantive change. I just am not familiar with this section, and I need to find out whether we need to do this. But it wouldn't change the effect of our act either way, whether we include that or not. 93.810.
It would simply be a reference to 93.810 as part of the curative paragraph.
Okay.
And
we would add 93.810 to the draft and just put a reference to the section that we already created, section 6, into 93.810. And as far as I can tell, this is just a list for the reader's convenience, basically, to see, here are some things you might want to look at if you have, something that doesn't appear to follow the law as it was. There may be a curative act that fixes that for you, and this is sort of a convenient list. So I will find out if we include that in all the drafts or sometimes or whatever. So, but it wouldn't change the effect of what we've done in the existing draft. And
then in that curative document, it refers to a new section 12 of 93.810. Is that something that is being included in what you're looking at, Marissa?
A new section 12.
Well,
I don't see.
subsection 12 in the first curative.
Yes, in the first
right.
curative.
So instead of, subsection 12 would be replaced with basically a description of section 6.
Okay, everybody following that? Because I'm not sure that I am.
I agree. I think 810 is just a laundry list of topics that have had curative provisions in them, and so therefore it's appropriate for the curative provision in section 6 to be added to this list.
Okay.
The list doesn't change anything.
That's fine. Everybody comfortable with recommending that the commission adopt LC 9990 as supplemented and amended as we've discussed? Hearing no objections here, so I think we've got at least our recommendation of referral to this to the commission.
So, Marissa, as soon as you're able, if you could get me a copy with the changes discussed today, I will get that to the Law Commission as soon as possible.
Yeah, I'll get it to you tomorrow, so you'll have it for Thursday.
Perfect. Thank you.
Okay. Well, I think that means that we really don't need to have a future meeting. At least that's my thought, unless somebody wants to.
Probably not a formal meeting. It's very possible that we've had some discussions about some work that we are planning on doing to educate folks. I know we've talked about educating judges and others to make sure they're comfortable with this going into the session. So it's likely not going to require a full meeting, but we might be reaching out to some folks here, also some of our partners with from national organizations to help us potentially setting up demos and things like that, which will help people better understand the concepts before we bring them in front of the legislature.
Okay, so you're not totally off the hook about a potential future meeting, but I think we've done all the corrections and suggestions that we can here today. Now it's going to be up to the commission to adopt this, and we go forward with it. And I want to say thank you for all of your participation. It's been great and great discussion. Hopefully we will have this before the legislature next go round. So again, thanks again.
Thank you.
Thank you, everybody.
Thank you, everybody, for all your hard work on this. I appreciate it.
Thank you. Okay.